Good morning, friends. Today I will discuss with you distinction between obiter dicta and ratio decidendi. When we appear on behalf of our client, we are to win our case depending upon the judgments we lay before the honorable court so that they may put their mind into the ratio decidendi of that case. Firstly, if we know which is obiter dicta and which is ratio decidendi, then we can effectively fight our case. So, a judicial statement in a legal case consists of two different elements which we refer as ratio decidendi or ratio simply and obiter dicta or obiter. Now, if we go by the Latin sense, then the ratio means reasons for the decision or judgment, while obiter usually refers to additional opinions or observations that are made on the issue. Obiter reveals the rationale adopted by courts to come to the conclusion and is non-binding part of judgment. No doubt, ratio is the reason behind the decision, but it is actually more than that. Ironically, when a precedent has multiple reasons, all reasons are binding. To find ratio of judgment, one should look at the abstract principles of law that have been applied to the facts of that particular case. Now coming to obiter dicta. Obiter generally refers to remarks made by the judge which are not binding upon the parties. Statements which are not crucial but refers to hypothetical facts or issues of law not related to case sometimes also form a part of obiter dicta in a judgment. Unlike ratios, obiter is not the subject of judicial decision, even if the statement made in this part are correct according to law. A decision of the higher courts, like Honorable Supreme Court and the High Courts, generally sets a precedent for the courts below to follow. Now, coming to how to test whether a particular proposition of law is to be treated as the ratio decidendi of the case, the proposition has to be inverted. So we have to inverse the proposition, that is to remove from the text of the judgment as if it did not exist. If the conclusion of the case would still have been the same even without examining the proposition, then it cannot be regarded as the ratio decidendi of the case. It is not the findings of material facts, direct and inferential, were the statements of the principles of law applicable to the legal problems disclosed by facts, which is vital element in the decision and operates as a precedent. Even the conclusion does not operate as a precedent, albeit operates as res judicata. Thus, it is not everything said by a judge when giving judgment that constitute a precedent. The only thing in a judge's decision binding as a legal precedent is the basic principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate from it the obiter dicta applying above principles. This is all about obiter dicta and ratio decidendi. So please be expert in finding out which is the ratio of the case so that you may get relief in the court of law. This is all about the subject. Thank you for watching. God bless you all. Meet you again.